One of the great privileges I have as Dean of the Law School is introducing lectures like this. We are blessed, thanks to the generosity of many of our alumni and friends, with the ability every year to put on a series of lectures, of which this is one of the premier in our intellectual firmament. Today, I'm pleased to welcome David Cole, Professor of Law at Georgetown University Law Center, a quite interesting and controversial writer, who is this year's Distinguished Ben C. Green Lecturer. We are also very fortunate to welcome our great friend, Ro Green. Ro has become a personal great friend, so it's doubly delightful to have her here. Ro was the daughter of the late Judge Ben C. Green, an alumnus of the class of 1930, and his late wife, Sylvia Green. In 1961, Judge Green was the first School of Law graduate to receive the prominent appointment of federal judge of the United States District Court for the Northern District of Ohio. His appointment was made by President John F. Kennedy, and he served in this role for 20 years. Judge Green, who possessed a true passion for legal education, was highly regarded in his profession and in the community. He also embraced a passion for politics and a commitment to his long judicial career. Fortunately for the School of Law, he also inspired the extraordinary philanthropy of his late wife and his wonderful daughter, who together established the Ben C. Green Visiting Professorship, which is now in fact a chaired permanent professorship held by Professor Kevin McMonigal. Later, Ro, on behalf of her family and in honor of her late father, gave the largest individual outright gift ever received by the law school for its significant library renovation, the Ben Green Law Library, and then went on to endow the lecture series that we enjoy this afternoon. Ro also continues to be one of Northeast Ohio's most dedicated philanthropists to our region's arts and cultural institutions, and is really an extraordinary force, not just in Northeast Ohio, but of course in Colorado and in other places in the United States, a real force for artistic innovation and artistic prominence. And in that respect, Ro is yet again a great, great philanthropist. We are really fortunate to have her generosity and that of her family. So it is an honor once again to say, Ro, thank you. Will you please stand? I also want to note that this lecture is of such importance that in our audience today is my boss, President Barbara Snyder. And it's a pleasure to have you here, President Snyder. Just a symbol. A real symbol of what intellectual engagement means and how important it is to our university and to our law school. Now I'd like to turn things over to Professor Bob Strassfeld, Associate Director of the Frederick K. Cox International Law Center and Director of the Institute for Global Security, Law, and Policy, who will introduce our speaker. Thank you.
Not to publicly correct my boss, but I'm the former director of the Institute for Global Security, Law, and Policy. I stepped down, but am serving in this function today. Anyways, it is a daunting task to introduce our speaker, whose CV is enormously long. And I won't try. I mean, for one thing, it's also an exercise in feeling inadequate that I don't really want to engage in. But let me say that Professor David Cole's contributions have been numerous, both as a scholar and as a public intellectual, writing on civil rights and national security issues, and as an advocate. And it's really quite an extraordinary track record, including important litigation before the Supreme Court, at least 7 books. Did I undercount? More or less, within the margin of error. And I could go on, but it would fill the time that is better spent listening to David. So I will tell one story, and I think that's illustrative. I met David at a conference, I believe it was the fall of 2003 at the University of North Carolina Law School. At that conference, the keynote speaker was Judge Michael Chertoff. Judge Chertoff was somebody who was an appropriate keynote speaker for the conference. He had served as a federal judge on the Third Circuit. Before that, he had been in charge of the criminal division of the Justice Department, where he guided the prosecution, the Moussaoui prosecution, the 20th hijacker. He had had a hand in the drafting of the Patriot Act. He certainly was somebody who knew something about national security, more than a little something about national security. He gave this keynote address, and at the end, the people came up from the crowd to the microphones to ask questions, and one of the people who came to the microphone to ask a question was Professor Cole. Judge Chertoff looked at him and said, "Not you." Now, Third Circuit judges don't intimidate easily, and Judge Chertoff subsequently, incidentally, went on to be the Secretary of Homeland Security under President Bush. Judge Chertoff was no shrinking violet, is no shrinking violet, an able legal thinker. You would think could hold his own, but nevertheless, he knew David by reputation, at least, maybe more than that, and decided to dodge the question. I don't know if his contempt power followed him down to North Carolina, but I guess at any rate he exercised the speaker's prerogative to dodge a difficult question. Today, however, we have the great privilege of hearing Professor Cole unsilenced and willing to take on all of the hard questions. So, without further ado.
Thank you, Bob. That introduction reminds me of something that Justice Brennan used to say after he would get introduced. He'd say, "I wish my parents would have been here to hear that introduction. My father would have been proud, and my mother would have believed it." I actually don't recall the moment in question, although I've had many run-ins with Judge Chertoff, so they all sort of come together. I thought that given that we are now 11 years to the day from the attacks of September 11th, that it would be worth looking back on that day and on the 11 years now that are now characterized as post 9/11 in almost any discussion, to ask what has changed and what has not changed, and what is surprising about what has changed and what has not changed. And of course, much has changed. We launched 2 wars, one against the country that supported those who attacked us on 9/11, the second against a country that did not attack us. We have spent over $3 trillion on those 2 wars alone. We have created a massive national security industrial complex in the United States and are spending tremendous amounts of money on preventive measures, which may or may not be preventing attacks that might or might not have occurred in the absence of such spending. Just one indication of how much we're spending, and remember, we're in this very difficult economy where money could be spent on many other things. We are spending $80 billion a year on counterterrorism initiatives, not counting the wars in Afghanistan and the post-war effort in Iraq. $80 billion a year. Conservative estimates say there might be 4,000 people out there who are associated with Al-Qaeda or Al-Qaeda affiliated or associated forces. So if you do the math, that comes down to spending $20 million per potential terrorist per year to prevent the next attack. And that, I think, that just incredible expenditures, which really are politically can't be questioned, right? We can question everything else. We can question spending money for health care. We can question spending money to get people back to work. We can question spending money to help the poor, but we can't question spending $20 million per potential terrorist per year. That, I think, will shape our existence and the questions we face as a nation for years to come, because it's very hard to stop that spending. And what that spending does is create a whole host of vested interests that have a strong interest in developing new technologies to monitor us more closely and the like. But that's not really what I want to talk about. What I want to talk about is what I think is in some ways a more surprising. That's hardly surprising, right? We were attacked in this vicious way. Nobody wants to see another attack. Hardly surprising that a lot of money is being spent trying to forestall another 9/11. What I think is more surprising is that the rule of law and constitutional and human rights proved, I think, far more resilient than many would have predicted on 9/11. You know, think back to that day and imagine that someone had come up to you and said, you know, the United States is not going to be able to get away with whatever it wants to in responding to this attack. You might well have thought that person was delusional, right? Because we had just suffered a horrific attack, one that justly horrified the world at large. We were the most powerful country in the world, with a military that dwarfs the next 20 nations' militaries combined. Al-Qaeda, our attackers, had few friends beyond the Taliban. And history had shown that in times of crisis, when people are afraid, Congress and the courts do not stop the president, and the people do not stop the president in doing whatever is necessary to maintain security. So the notion that somehow we wouldn't be able to do whatever we wanted to do might well have seemed a little crazy. But yet I think when you look back on the decade plus one that we have now seen since 9/11, what is to me surprising is that the rule of law and commitments to constitutional and human rights were actually more resilient than we might have expected. And, this is the second part, that the cause of that resiliency, the cause of the pushback to the responses that we initially undertook in the name of security after 9/11 is not, for the most part, the formal institutions of government, is not the separation of powers, is not what we generally think of as the way our Constitution works. One branch of government checking another. Congress didn't check the president after 9/11. The court, to a greater degree than in prior periods, checked the president, but as I will suggest, in relatively minimal ways, checked the president. The people as a whole did not demand that the president retract many of his most aggressive measures, and yet the President Bush, this is, was compelled to retract virtually all of his most aggressive post-9/11 security measures to bring them closer to conformity with the rule of law. And I'll suggest that one of the principal movers in pushing back was civil society, was people, us, not governmental institutions, but ordinary people joined together in associations that were defined by their commitment to constitutional and human rights and provided much of the impetus and organizing that created the resistance that resurrected the rights that lead us to where we are today. So first, a little bit of review. We should not forget, we must not forget, many of the things that we did in the immediate aftermath of 9/11. There's very little question that many in the administration at that time felt that there would be no check on what they did, and so acted accordingly. So President Bush most famously authorized torture of al-Qaeda suspects, authorized rendition to other countries so that they could torture the suspects for us when our own tactics did not get us the answers we wanted, authorized the holding of hundreds of detainees at Guantanamo Bay in secret, without any hearings, without any opportunity for them to respond to any charge against them, without any lawyers, without any protections of the Geneva Conventions, which generally protect prisoners of war. And they, too, were subjected to abusive and, in some instances, torturous interrogations. President Bush created or authorized the creation of secret prisons run by the CIA throughout Europe and Eastern Europe, in which we disappeared suspects for years at a time, picked people up around the world, and swept them into these secret prisons where we did not acknowledge that we had them. We did not allow the Red Cross to visit them. We disappeared them. Disappearances was something that we know from Latin America, but in the wake of 9/11, we adopted that tactic as well. President Bush authorized the creation of military commissions that could execute people on the basis of evidence obtained through torture without any judicial review. He took the position that the Geneva Conventions don't protect al-Qaeda suspects, and that the Convention Against Torture's prohibition on cruel, inhuman, and degrading treatment doesn't protect anybody who's a foreigner outside of our borders. He took the position that as president, he had the power as commander-in-chief to ignore the law. It really sort of calls to mind President Nixon, who was interviewed by David Frost, and Frost asked him why he thought he could authorize warrantless wiretapping of Americans during the Vietnam War. And President Nixon said, well, it's my understanding that if the president does it, that means it's not illegal. Now, President Nixon learned the hard way that that's actually not the American system of justice, but President Bush essentially resurrected it with a minor, twist, citing the commander-in-chief power. And I suppose you might say, as a practical matter, the theory was if the vice president is named Dick Cheney and does it, that means it's not illegal. On that basis, they authorized the warrantless wiretapping of American citizens in violation of a statute passed by Congress that says it's a crime to engage in warrantless wiretapping. So that's just a reminder of some of the things that happened in the immediate aftermath of 9/11. I think that's deeply disappointing, deeply disturbing, not all that surprising, given who we were, given the attacks that we faced, given the pressures that were on the administration to avoid another attack. What's more surprising to me is that Bush was forced to retreat on virtually all of these measures. So when the torture memo authorizing waterboarding and the like, was leaked to the press and published by the Washington Post, immediately it was retracted. They could not defend in public what they had, said was legally proper behind closed doors. Renditions to torture were largely halted when many of our allies, especially in Europe, vociferously objected to the practice. The detainees disappeared in secret black sites, CIA prisons, were transferred from those prisons by President Bush and sent to Guantanamo, where they could be represented by attorneys, could be visited by the International Committee for the Red Cross and the like. President Bush gave Guantanamo detainees hearings in which they could present their defense before the Supreme Court even ruled on any of the Guantanamo cases. President Bush released over 500 of the 775 detainees held at Guantanamo. He ended the warrantless wiretapping program and instead went to a court and got a court-authorized wiretapping program that is subject to both judicial and congressional oversight. Then President Obama came into power and he went further. He closed the black sites. They were sort of not being used, but he closed them. He formally ended torture. He promised to close Guantanamo, hasn't succeeded in that promise, but largely because of congressional opposition. He released the formerly secret torture memos that in detail showed how some of our best lawyers legitimized the use of coercive, cruel, inhuman, and torturous tactics. President Obama refused to rely on the inherent commander-in-chief power to ignore the law that President Bush had advanced repeatedly in the courts. At one point, the D.C. Circuit in one of the Guantanamo cases ruled that the laws of war and international law do not bind the president in how he detains people at Guantanamo. And President Obama did a remarkable thing. He filed a petition with the court saying, "You're wrong, you gave me too much power. Actually, my authority is constrained by the laws of war and must be constrained by the laws of war." And the full D.C. Circuit vacated the decision of the panel, which had said the contrary. When ever has a president said, "You've given me too much power"? President Obama has released about 100 more Guantanamo detainees, and he has taken the position that we can and should pursue national security within the law, not by thrusting the law to one side, and that we're actually stronger when we do so. President Obama is far from perfect. He has continued to advance a very broad view of the state secrets privilege, which bars civil suits that allege unconstitutional action by the government if the government claims its own allegedly unconstitutional action is a secret, even if it's been reported on the front page of the New York Times. He has defended a very expansive interpretation of the material support statute, which makes it a crime to even advocate for peace and human rights if you're doing so with an organization that the Secretary of State has designated on a blacklist as a terrorist group. He has successfully blocked habeas corpus review of the detentions at Bagram. He has authorized the targeted killing of many people, including U.S. citizens, outside of this country under the drone policy, and has done so in secret without even telling us what the constraints are on the president's authority to kill us. And he has refused to pursue any accountability for those who authorized torture, sort of one of the core war crimes and human rights violations known to mankind. So There's no perfection here with either administration, but I think to me, what is surprising when we look back is that there was this progression away from these aggressive assertions of power in which the rule of law and sort of more law-bound responses became more significant in our counterterrorism policy and practice. Now, I want to say two things about that. First is that one thing we might learn from this is that we are no less safe, and we are incurring much less cost in pursuing a counterterrorism policy that conforms to law as opposed to throws law overboard or defies law in the name of some inherent commander-in-chief authority to keep us safe. There's no evidence that we were less safe in the second Bush administration, which was more law-bound, than the first Bush administration. And there's no evidence that we are less safe in under the Obama administration than we were under the Bush administration. Nor is there any evidence that the most extreme tactics employed by President Bush actually did all that much for us. The CIA's own Inspector General did a study of their enhanced interrogation program and concluded that it could not find that those tactics had obtained any information that could not have been obtained through lawful means, and much of it had previously been obtained through lawful means. They also found that there were no imminent plots disrupted by information obtained through that program. You know, you often hear about the ticking time bomb. Torture is justified with the ticking time bomb. There were no ticking time bombs. And you have the accounts of U.S. interrogators, Ali Soufan and Matthew Alexander, who write that we were getting better and more information from these exact suspects, because they were interrogating them, when we were doing so within the constraints of the rule of law than we did thereafter. These measures also were, of course, significantly costly. They have created tremendous roadblocks and barriers to bringing to justice the people who were responsible for the attacks of 9/11 and other attempted attacks against us, because when you torture people, it's very hard to hold them accountable in a court of law. And so here we are 11 years after 9/11. We have a number of the suspects in custody, and they have yet to be brought to trial. And we're going to bring them to trial only in a military commission in a courtroom where they have a soundproof plexiglass wall between the well of the court and the audience. Why? So that anytime any of the suspects happens to mention the way he was treated by the CIA during the enhanced interrogation technique, they can cut off the sound and keep it a secret from the world. Well, they haven't kept it a secret from the world, and by employing those tactics, we squandered much of the world's sympathy, gave Al-Qaeda the best propaganda it could hope for, and caused the polls to find the highest levels of anti-Americanism around the world that have ever been registered. This was after we were attacked in this horrific way. So I think, you know, one thing we can learn is that we don't need to go down this route, and going down this route is actually deeply costly. But I want to spend more time talking about what caused this resurrection, partial as it is, of rule of law values. And you know, I think that the standard story that you learn in constitutional law is that it is constitutional law exercised through principally judicial review and secondarily the separation of powers, the fights between the branches, that checks governmental abuse. And I think in ordinary times that works pretty well. But it tends not to work very well in crises. Right? In World War I, it didn't work very well. When Congress made it a crime to speak out against the war, the executive prosecuted hundreds for merely speaking out against the war, and the Supreme Court upheld the convictions. In World War II, it didn't work out very well when Franklin Delano Roosevelt authorized the internment of 110 to 120,000 people simply because they were of Japanese ancestry, 70,000 of them U.S. citizens. And the Supreme Court upheld that practice. It didn't work out that well during the McCarthy era when anti-communist measures imposed guilt by association, criminalized speech, and the Supreme Court basically stayed its hand, did not intervene, did not protect speech or association until McCarthy was on the way down and had been censored by the Senate. And only then did we get relatively robust First Amendment protections from the court. So in times of crisis, the separation of powers doesn't really work all that well. The president is pushing in the way of security, the Congress is pushing in the way of security, and the courts are doing everything they can to stay out of their way, and the people as a whole want security, right? They want security, and so it's not surprising that in these times you see overreactions and abuses. This time, Congress again basically did not stand in the president's way. It effectively reversed two Supreme Court decisions against the president to allow the military commissions to go forward, to repeal the habeas corpus statute that the Supreme Court had said gave Guantanamo detainees a right to come to court to challenge the legality of their detention. It enacted the Patriot Act in short order, giving the president very broad authorities, many of them without significant review. One major exception, it did when it learned that the president had taken this view that the prohibition on cruel, inhuman, and degrading treatment that's found in the Convention Against Torture didn't protect foreign nationals held abroad. A really remarkable position because this is an international human rights treaty. It doesn't turn on, what passport you have. Human rights don't turn on what passport you have or where you are. They turn on your humanity. And the president said, oh no, it doesn't turn on your humanity. It turns on whether you have a U.S. passport or not. Well, when Congress learned of that, thanks to John McCain and his leadership, they enacted the McCain Amendment, which said squarely, no, this applies to every human being wherever he is held. You can't avoid it. That was the good news. The bad news was that they made it unenforceable. So that's Congress. The court was less deferential than it's been in the past, as I suggested earlier. And I want to talk about those decisions, but I think it's important to start by noting that virtually all of the retreats that I listed, all of the pullbacks in which the executive branch brought its actions more in conformity with the rule of law, were undertaken without a court order and without congressional pushback. So the 500 detainees released under President Bush and the 100 more under President Obama, no court ordered those detainees to be released, and yet they were released. Congress didn't order them to be released, and yet they were released. Neither Congress nor the court required hearings at Guantanamo or lawyers at Guantanamo, and yet the Bush administration provided that. Neither Congress nor the courts ordered the end of torture or rendition or the closure of the black sites or the end of warrantless wiretapping, and yet we saw all of those happen. So something was going on that was pushing the Bush administration, but it wasn't formal institutions of government. There were, as I said, 4 important Supreme Court decisions, and I think they were important, and they were important in some informal ways as well as formal ways. But when you actually look at them, a couple things become clear. One is that they're relatively limited in what they actually required. And two is that they took a tremendous amount of work, much of it independent work by the Supreme Court justices, raising the question, why did they do so much work? Right? Why did they do so much work? It wasn't as if these decisions were foreordained by precedent. In fact, the precedent that existed, much of it from World War II, was on the president's side. And the court had to do a lot of work to rule against the president. Doctrine didn't compel it to do so, which raises the question, what did? So on the sort of these were limited in what they required, two cases, the first and the last, Rasool and Boumediene, were just about whether the Guantanamo detainees could get in the courthouse door. That's it. Not about substance, just about process. The court said yes, both times. Rasool and Hamdan was the case about the military commissions authorized by the president, were decided by the court against the president, but on statutory grounds, meaning that Congress could reverse the court, and in fact, in both instances, Congress did promptly reverse the court. Hamdi was the only case involving a U.S. citizen. He was the U.S. citizen captured on the battlefield in Afghanistan fighting with the Taliban, allegedly, and detained as an enemy combatant. And the court held that he had a right to a hearing. They left sort of vague what that hearing would look like. And the president avoided ever finding out what that hearing would look like because he let him go rather than give him a hearing. But that decision applied to two people. There were only two U.S. citizens ever held as enemy combatants, Mr. Hamdi and Mr. Padilla. So pretty limited in what they actually required. Also, quite remarkable the amount of work the court had to do to get there. The court had, during World War II, held that enemy combatants held outside the United States could not come into federal court. And yet, here the court held the opposite twice. And the court had, in Ex parte Quirin, upheld a very rudimentary executive-created military commission for the trial of war crimes. And here the court invalidated President Bush's order, which was modeled on President Franklin Delano Roosevelt's. So the law did not command these results. And you have to ask, what was it that got the court to decide them in the way that it did? Finally, there wasn't a tremendous sort of broad political demand for President Bush to roll back his initiatives. Political pressure was, in some sense, limited by a number of things. One, most of the victims were foreigners. There was a lot of secrecy that made it difficult for people to know exactly what was going on. And people care about their security. And if they're told, look, you have your security and we'll take away somebody else's rights, that doesn't generally trigger a lot of political opposition. So where was the opposition? Who was pushing back? Where was the resistance? And I think the answer is in civil society. And by civil society, I mean in particular groups, those non-governmental organizations that organize themselves around a commitment to constitutional and human rights. Groups like the ACLU, the Center for Constitutional Rights, Human Rights Watch, Human Rights First, Amnesty International, the American Arab Anti-Discrimination Committee, the Council on American Islamic Relations, which is the leading Muslim civil rights organization in the country, the Bill of Rights Defense Committee, a host of organizations of people, just ordinary people. But why did they come together? They came together around a commitment to certain rights. And they happened to be the very rights that were under attack. And so they responded. They responded by filing lawsuits, by issuing statements, by doing investigative reports, by leaking information to the press, by educating the press, by organizing petition drives around the country, internet campaigns, interestingly and I think very effectively working transnationally to get pressure brought to bear from other countries on our country, which made a lot of sense because the victims, as I said before, were mostly foreigners at Guantanamo. The detainees are from 42 different countries. And many of the releases there stemmed from criticism brought to bear on the United States by those foreign countries with which we needed to work if we were going to be secure. And it was civil society groups that did a lot of the work to make that happen. And it wasn't just the work they did after 9/11 to make that happen, but also before 9/11. So, you know, Korematsu, which is the case in which the Supreme Court upheld the internment of 120,000 Japanese and Japanese Americans, was not the end of that question. It was the Supreme Court has the final word, but they didn't really have the final word. Why not? Because civil society groups, Asian American groups in the ACLU, continued to fight for the notion that that was wrong for 40 years. And in the 1980s, they prevailed. The courts vacated the convictions of those who had refused to abide by internment, and Congress enacted a law signed by President Reagan that officially apologized for the wrong that was done and paid reparations to the survivors. And that work, the work of civil society, in turn, I think, affected the Supreme Court's approach to the Guantanamo cases. Fred Korematsu actually filed an amicus brief in the Supreme Court and said, don't do what they did. Don't make the same mistake twice. And by that time, this was a Supreme Court decision, right, Korematsu. By the time that the case got to the Supreme Court, virtually every Supreme Court justice had publicly said Korematsu was wrong. They hadn't overturned it because there wasn't another Korematsu, but they had, all but Justice Souter had said it was wrong. And Justice Souter is just a little more discreet than the rest of the justices. It's not that he thought it was right. And that, I think, had a tremendous impact on the court's willingness to stand up this time in some measure to the president. So I think I want to suggest three implications from this, and then I'll close and take questions. One is an implication for constitutional theory and how we as scholars study and think about the Constitution. The second is an implication for constitutional doctrine, what the rules should be. And the third is an implication for constitutional practice, how we live as citizens in a constitutional democracy. The first is what I would call civil society constitutionalism, that when we think about constitutional law and how it operates, we should not stop at the Supreme Court or Congress or the executive or, as some have said, the people themselves. What I think is very much worth study is these organizations that are just ordinary citizens who come together around a set of commitments. And what is that set of commitments? It is the set of commitments that the Constitution reflects. We talk about the Constitution as being a living Constitution, but that's a metaphor, right? But these groups are actually living embodiments of people who have come together for the purpose of defending and making real these constitutional commitments. And so at a time when all of the pressure in society is going in one direction towards security, these groups, because they're defined by their commitment to these rights, are actually pushing back. And they're doing well by pushing back. The ACLU grew in unprecedented ways in terms of its membership and its funding in the post-9/11 era. So did the Council on American-Islamic Relations. These groups did well by pushing back. So their institutional incentives are there to stand up for the Constitution precisely at a time when nobody else is, and when the separation of powers and formal structures of government are not. And so I think it's important that we look at the role that civil society plays in making constitutions meaningful, and understand that much of the work of constitutionalism takes place within civil society, not within the court, Congress, or the executive, but within civil society. And of course, civil society works through and with these entities and by putting pressure on these branches, but it is they who are often doing the work. The second implication is an implication for doctrine, for constitutional doctrine, and that is, if it's true that civil society is critical, a robust civil society is critical to a meaningful constitution, right? There are a lot of countries that have constitutions that look just as good as ours on paper, but they don't have robust civil societies, and they don't have meaningful constitutional protection. But if it's true that civil society is critical to a robust constitutional culture, then it's critical that we protect the space that civil society operates in. And here the doctrinal implication of that is the critical importance of protecting First Amendment freedoms of association and speech. Ironically, the one case in which the Supreme Court ruled did not rule against the executive, did not stand up for rights, was in the post-9/11 national security context. Well, it's not the one case, probably the most important one where they didn't, involved the rights of speech and association. That's Holder versus Humanitarian Law Project, in which the court upheld the material support statutes as applied to a humanitarian law group that was seeking to advocate for peace and human rights in conjunction with a Turkish group that we had labeled terrorist. And the Supreme Court said, even though all you're doing is advocating for peace and human rights, it's constitutional for Congress to make it a crime for you to do so. That, I think, undermines the space within which civil society needs to operate if it's going to make constitutionalism robust. And then the third and final lesson is a lesson of what I would call constitutional practice. How do we live as citizens in a constitutional community? And it seems to me that if the strength of the Constitution turns on us, and in particular on our working together through political associations committed to its values, then it's critical that we get involved, that we get engaged, that we support the associations that are doing this work. We join them, or if we think they're not doing a good job, we create organizations ourselves. I was inspired in writing this lecture by two quotes. One comes from Learned Hand, who wrote that liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it. Now, like all great quotes, it overstates the case a little bit, but I think the core message is critically important, and that is that liberty lies with us. And what I would add to that is that the way we ensure that liberty lies in the hearts of men and women is through engaged commitments through civil society to those very values. And then finally, I want to close with another a quote from this one from Cornel West and Roberto Unger in a book on the future of American progressivism. It was a very thin book, I guess the future of America, physically, not, I'm not making an editorial comment. But this quote, I think, has always stuck with me, and it's about why people fight for justice. And they write, "Hope is more the consequence of action than its cause. As the experience of the spectator favors fatalism, so the experience of the agent produces hope." And what I think they are getting at there is that people don't get engaged because they have hope, but rather they develop hope through engagement. And so the future of our Constitution and of human rights ultimately depends on the engagement of us all. Thank you very much. I have time for questions, objections, amendments, what have you. There's two.
Down to the microphone.
There's two mics so people can hear you.
Hi, David. Thank you very much. I'm Avi Cover from Case Western. I'm curious, I guess, I was very struck by the notion of civil society as sort of the lens through which to view all this. I know one critique, perhaps some self-criticism by some of the groups that you were discussing, was that the approach to advocacy had often been through a very patriotic American lens. I think of sort of the military leaders, John McCain saying, it's not like us, it's not American to do these things. And that one criticism of that, one failure perhaps in that approach is that the country did not look outward. That actually, while upholding this sort of notion of city on a hill and what have you, there was less recourse to, in some respects, rule of law, quite seriously, the international law and human rights. A failure, and some xenophobia in there, a failure to look at the victims. And so we've seen a failure of accountability. We've seen in the targeted killings, I think, generally less outcry than one might expect. So I wonder, is that a fair criticism, perhaps, of the civil society approach?
Well, I don't know. I mean, I think that it may be with respect to some civil society. I don't think you can make a broad generalization about the ways these civil society organizations reacted. But I would say that I think if you did a comparative look at sort of how civil society responded in this period to prior periods, there would be more international engagement, more efforts to bring other voices from other countries to bear on what the United States was doing. And and partly that's because we live in a globalized world. It's partly because the internet makes it a heck of a lot easier. Human Rights Watch can do a report and put it on the internet, and it's accessible everywhere except China, right? So getting the information to those places is important. But I'm struck, for example, by one civil society organization that was created in the wake of 9/11 by lawyers who were representing Guantanamo detainees, and it's called Reprieve, and they represented something between 35 and 50 Guantanamo detainees over the course of this period. And when they decided to create an office, they put it in London, not in Washington, D.C. And when I asked them why, they said, because we felt that we were much more likely to get relief for our clients through diplomatic pressure brought to bear by our special friend, the UK, and by Europe and other foreign governments, than by going into court. And they did go into court, but they also did a very sophisticated international work. And ultimately, I think all but one of their detainees has been released, and none of them by a court order. So I think maybe some entities have been, more closed about it, but I think there's been a pretty broad understanding that, the other thing is that the rights at issue for many of these people were maybe constitutional rights in some instances, certainly constitutional rights in some instances, but because there's a real question about how far the Constitution goes beyond our borders, sometimes not clearly constitutional rights, but they were certainly human rights, and so which have an international basis and flavor and appeal, and so there was a lot of that work. I think that what you saw in the wake of 9/11 was a kind of coming together of the tactics of constitutional rights groups, domestic constitutional rights groups, which traditionally have been court-focused, and human rights groups, which, human rights groups have traditionally, they operate in places where there are no courts, right? There is no, or there are courts, but they're not, you can't really go in there and argue that the government has done something wrong. You won't get anywhere if you do. The hard law is basically ineffectual, and so they have adopted soft law tactics of reports, of shaming, of bringing diplomatic pressure to bear and the like, and I think we saw that kind of an amalgam of that with the ACLU engaging in that and the Center for Constitutional Rights, sort of more domestic groups engaging in that in a fairly robust way. So that'd be my response. Yeah.
Hi, it's a pleasure to have you here. My name is Jabba Shabalala. I'm teaching at Maastricht. I'm visiting here at Case. It's sort of an added facet to Avi's question, which is, when you look at what was described as sort of a pre-September 11th framework for the broadening of American constitutionalism and sort of legal thinking to begin to include non-citizens in some fashion in a more sort of friendly or at least more open way, what happened after the September 11th bombing suggests sort of a fundamental break that there seems to be, and I wonder if there's any way to ever get back to that after the bombing of September 11th, a real break in the treatment of citizens versus non-citizens. That there really is now, both as a matter of legal structure, and I think potentially as a matter of political and social structure, a real sort of divide in the way that citizens and non-citizens are treated.
Yeah.
So my question is, having seen sort of some of the retreats that you talk about, do you think there is a pathway back to re-engaging and reopening a pathway to a more open treatment of non-citizens in the legal framework?
Yeah, that's a great question. I'd say a couple of things. One is that this sort of, divide between citizens and non-citizens, the double standards, et cetera, is not new to, post 9/11. My first post 9/11 book was called Enemy Aliens, Double Standards and Constitutional Freedoms in the War on Terrorism, and what I did in that book was to really situate the post 9/11 response, which I think was predicated on double standards, on this notion that we will preserve our security by taking away their rights, and therefore we don't need to worry about it. That's we've seen that pattern before. In fact, in every prior security crisis, the initial response takes that form. So, I don't think in that respect it was new. It certainly created more pressure to do that. I think the Boumediene case is probably the most positive post 9/11 sign of some resistance to that within our system, right? So the principal argument there was that these people don't have rights that citizens would clearly have in getting into court and bringing law to bear on the circumstances of their detention. And the Supreme Court said, no, they have a right to come into court in the first habeas case, Rasool. And then when Congress said, actually, no, they don't have a right to come into court and repealed that statute, the court then, really for the first time ever, overturned the president and Congress acting together on a question of national security during a time of crisis with respect to foreign national. So that's something of a positive sign. And I think, but I do think that this is one of the great challenges that any political community, right, faces, which is the extent to which you're willing to accord to others the rights and dignity that you insist for yourselves. And that continues to be a challenge for us, as it does for most other countries. And I'm not, hugely optimistic that we're going to get to some perfect place on that. But I do think that the international human rights movement and globalization have created some impetus towards more of an understanding that when states operate to deny basic human rights of anyone, anywhere, they should be held accountable. Okay, well, we are right on the dot at 5:30, so I'll let Bob finish up.
So, first of all, thank you, and as a token of our gratitude. There's actually something in there as well. There is a reception in, I assume, the lower rotunda, which is around the corner. So first of all, please join me in thanking Professor Cole again. And then you can join us in partaking around the corner.
It's just what I need. I can put my papers in here. I won't lose them.
Well, and